possible rain. Dave Gladish, let's go straight to Michael Jackson. Where are we?
The defense in this case is rested. Now, in every case where it's a criminal case, and there was some discussion early on this morning, whether somebody's convicted or found liable. In a criminal context, it's a conviction by the state against the individual or by the federal government against the individual. If you have a civil case, you are found to be liable or not liable. So there's a difference there. Just because I heard some conversations earlier this morning, and just make sure everyone understands the difference.
So which one is this?
This would be the state of California versus Dr. Murray. Now, Dr. Murray is 58 years old. He was, I'm pretty sure he's a board-certified cardiologist, if I'm not mistaken. I'm pretty sure about that. And basically the allegation is that he acted recklessly in providing an anesthetic propofol as it relates to allowing Michael Jackson to fall into a deep sleep. He was having problems. He was an insomniac. The defense has been put forth in this case that Michael Jackson may have administered the lethal dose to himself. But when the evidence and arguments were presented to the jury in this case, based upon what I've seen and heard, there is no physical evidence to show that Michael Jackson either had a fingerprint or could have or was in a position to actually administer the lethal dose. So that's very damning for his case. The second is that all the expert testimony in this case also demonstrated that the use of propofol in this type of situation was contraindicated in the medical profession, that you should not use this type of medication, this heavy anesthetic, to induce sleep for somebody who's an insomniac. So I think that the evidence is very strongly against the doctor in this case, and my guess is he's going to be convicted. But we'll see what the jury does. We've had some situations where people were sure. We had the situation with down in Florida with the mother and the small child, and everyone thought for sure she was going to be convicted, and the jury acquitted her. So we'll see what happens here. Michael Jackson, a star. You've had the family there, some star power. I don't know if that's going to influence the jury or not, but it's something to definitely keep in mind. That is this jury going to walk out, especially after the Casey Anthony case. Those jurors have felt such a backlash for their decision. Would a jury in this high-profile case do something similar? And my guess is no.
Alexis and I were watching this the other day, and I guess as far as I could take it from the layperson, the prosecution was really going after two things. It was really kind of making it look like how could Michael Jackson really have put this in himself. And then the second part was to show that he was just being very reckless. He was on the phone. He had all these drugs laying around him. He was a known drug user. Even if Michael Jackson did administer it to himself and the folks came up with that, they still had to come to the conclusion that the Dr. Murray was way outside the bounds of normal medical practice.
Correct. Continuing to act, knowing that there was a strong likelihood for death or extreme danger to his patient is what the prosecution is focusing on. And also the issue is, he made some recordings of Michael Jackson interviews that have been played on TV, and in those interviews you could see that Michael Jackson was barely lucid, that he was making statements that showed that he was not really mentally where he should be, and the issue is the doctor's the gatekeeper, so he has an obligation to say to his patient, no, you cannot have that. No, this is not medically necessary. No, this is not the proper course of conduct. He was receiving, if I'm not mistaken, $100,000 a month to be this personal physician for Michael Jackson, and he was there to make sure that he was healthy. He was able to go on this tour and make a lot of money for Michael Jackson as well as everybody else, and it seems that he really failed in following through on
Dave
what
Gladish in the house. Let's move on. What do we have next?
You want to talk about Mr. Cain?
Yes, I do.
All right, now there's, again, this goes, and I did a little extra research before I came in today because of listening to some of the callers in the morning. Again, there's some issues. We had the one caller, and I know you were having a discussion with that individual about him being a conservative Democrat and so forth. And
conservative Republican.
I think it was
no, the guy was a conservative Democrat. You're
correct.
Right, yeah.
And then
okay.
You were saying that now there's the issue of whether he was found guilty on these prior charges of sexual harassment. So let's talk about, first of all, what is sexual harassment?
Okay, hold on. Let's just back it up. Herman Cain is running on the Republican side, and he is front runner in the polls. And as soon as he gets to be the front runner of the polls, these kind of weird sexual harassment allegations start coming out against him. His camp is saying that they're a smear campaign because he's leading in the polls. Is there a race element? Also, he is a black man, of course, and he's a black conservative. It's not all that unfathomable that this was going to come out at some point. They were going to come after him personally because he is rising in the polls. So now there's 2 women, I guess, where they were settled with, and then now there's a third that's saying he made an inappropriate comment to her at some point. So there's the background. So where do we go from here?
In reference to, first of all, let's talk about what sexual harassment is. He was in a position of power within his National Restaurant Association, and the arguments in reference to sexual harassment can be quid pro quo, which means if you do this for me, I'll do this for you. So basically, if you'll have sex, if you'll do this, if you'll do that, maybe I'll give you promotion, maybe I'll give you a raise, I'll give you vacation time, and so forth. That is a classic example of sexual harassment. The other is a hostile work environment, where, let's say, every day you come in, comments are made, there's inappropriate touching, there is offers of continued sexual advances with them and turned down, and usually it's from a superior to somebody in a lower position within the company. So when you have a supervisor making statements to somebody that is under their supervision or can adversely affect their work, that's where we come into the situation where we've got the sexual harassment claims. And there are standards. Now, not only can the harasser be held responsible, but also the employer. And basically, for the employer to escape liability, there is a standard put in place, and it's that did the employer exercise reasonable care to prevent or correct promptly any sexual harassing behavior, and that the employee unreasonably failed to take advantage of these corrective opportunities. So normally, all good businesses now are going to have a sexual harassment policy, defining what sexual harassment is, and also allowing the employee to have the opportunity to invoke this policy to protect them from the harassing behavior. So you cannot just say, well, he harassed me, now I'm going to sue my employer. No, you have to say, okay, I reported this. In this instance, Mr. Cain was, he touched me. He said if I did this, he would give me a promotion. He would let me have an extra week off work, whatever the situation is. Now, the allegations that they're coming out sporadically, and it's something along the lines of Mr. Cain, in one instance, said that this lady was a similar height as his wife, and he got too close to her and may have touched her. The other allegation that's coming out, and this is the more explosive one, that he had some type of corporate condo, and he continued to invite this woman up to the condo, and that there was an episode where he was drinking a lot, or there was a lot of drinking going on, and comments were made. Now, in reference to those 2 cases, again, I don't have any actual knowledge of these, but in one instance, the individual received $33,000, which was a 1-year salary, which is a substantial amount of money, but she had to give up her employment as part of that settlement. So you got to say to yourself, well, that's not that much money in the context of, with litigation, the cost, everything associated with it. Was that a lot of money? The other claim, though, and I think that one goes with the drinking in the corporate condo. It's my understanding, based upon some of the things that I've read, that there could have been a payment as large as $400,000, which now you're talking that is a substantial settlement of a sexual harassment claim. Now, the damages in the sexual harassment claim could be loss of earning capacity, it could be attorney's fees, it could be expenses. There's a lot of things that go into determining what the value of a sexual harassment claim is.